What are the employer's obligations when it comes to the actual administration of these leaves? The employer's obligation starts prior to the commencement of any leave that an employee may be entitled to. Now, that comes in the form of posting of the applicable mandatory postings and the notices that the employer must give to its employees, all new employees at the time of hire. These postings and notices are available on the CRD's website and then the Department of Labor for the FMLA. You must provide certain notices to employees at the time of hire. That's where your employee handbook comes into play. That's where you want to have your policies regarding CFRA, PDL, FMLA, and some of these other protected leaves in your handbook. So the employees are notified of when they may or may not be entitled to these leaves and the method that the employer uses to calculate the 12-month period for the and eligibility requirements for the leave. Now, once there is an actual request made or that you know that the employee will need to take a particular leave, depending on the circumstance and the need for the leave, you will first determine whether or not the employee is eligible for the leave, whether it's a CFRA or FMLA. You want to go through the process of making sure that the applicable documents and the notices are provided to the employee in a timely manner, that you collect the forms back from the employee. You want to follow up with the employee if the forms are not received in a timely manner. If there is a need for extension of the leave, for example, an employee who's entitled to 12 weeks of FMLA may initially have only requested 3 or 4 weeks based on the initial medical certification. Right before the end of the initial time frame, they may need an extension. And if that's required, then you can request an updated medical certification. You want to make sure that you're tracking the time the employee is taking appropriately under the designated leave, whether it's CFRA, FMLA, PDL, or if FMLA, CFRA, or FMLA and CFRA are running concurrently. The documentation and the communication essentially starts with when the employee makes the request. Now, you can have depending on the employer's policy, you could have a policy that the employee must request the leave in writing or verbally, but this is again optional. It's not required under the law that the employee must expressly request this. Then you must provide the employee with the notice in terms of what type of leave the employee is requesting, whether it's if they're eligible for the leave, and how the leave is being designated. Again, depending on the reason for the leave and the employee's eligibility, you will be designating the leave either as CFRA, FMLA, or concurrently PDL, FMLA, or just PDL on its own, and CFRA subsequent to that. At the time that the employee requests the leave, you must also give the employee certain pamphlets and notices regarding their rights and obligations, especially for PDL. There is your rights and obligations as a pregnant employee. The employees are generally required to give 30 days in advance notice if the leave is foreseeable. If not, then they must provide notice as soon as possible. Additional documentation will be certification of the healthcare provider, especially if this is for the employee or family member's medical condition, certification of healthcare provider for pregnancy disability leave or transfer reasonable accommodation for pregnancy disability. You can require a certification for pregnancy disability leave only if you are requiring the same for other disability leaves. You must give the employee 15 days to respond to the request for the medical certification. You're going to provide the employee notice of their rights and obligations. So this is under the notice requirement for the documentation and communication. You're going to provide the notice to the employee and regarding their rights and obligations under CFRA and FMLA. You're going to provide employee the notice as to how the leave is being designated, whether it's running concurrently with another leave, for example, FMLA CFRA or FMLA PDL. You want to provide employees notice within 5 days of determination under CFRA or within 5 days of the request of FMLA or PDL leave of what the determination is, whether they qualified or didn't qualify. The designation form is also used to inform the employee if you need more information before you make the determination, or if the leave is denied, you will need to provide the employee reasons as to why the leave may be denied. When it comes to certification, you must give the employee 15 calendar days to respond once you request that a medical certification is necessary. Advise the employee of the need for the medical certification, give them 15 days, inform them what constitutes a medical certification and the consequences for failing to provide the requested certification, which is that the leave would be denied if they fail to provide the certification. Other leave entitlement. So once the employee uses the particular leave that you have designated them under, for example, CFRA for their own serious health condition, if the employee is still requesting additional leave, you may want to evaluate to see if there is some other leave that they may be entitled to. Here, an obvious example would be an employee who was on PDL leave, which ends, then they may be entitled to and may request baby bonding under CFRA. So there's the additional 12 weeks that they would be entitled to for either baby bonding, or if they continue to be disabled from the pregnancy, then it would be for their own serious medical condition. So again, there's additional notices under CFRA that would be triggered once PDL ends and the employee begins their CFRA leave. So you would go back to all the designation, the proper designation, and then tracking of the CFRA time once that time begins. And then finally, if there is leave extension, you want to ask for updated medical certification. So each time the employee wants to extend the leave and the prior medical certification has expired, you can ask the employee for additional updated medical certification. Extension of leave and additional reasonable accommodation goes hand in hand here. Medical leave, obviously leave of absence, is a form of reasonable accommodation. However, there is additional extension if the employee, as we spoke about at the very beginning, has already used their entitled leave. What else is the employer's obligation if they still need additional leave? The starting point of that analysis is that CFRA, FMLA, and PDL are separate and distinct from the right to take a leave of absence as a reasonable accommodation. An employee may continue to be disabled beyond their entitlement to leave under one of the protected leave categories. An employee can take additional leave as reasonable accommodation under FEHA or ADA, and then a duty to accommodate and provide the additional leave under FEHA needs to be determined, or under ADA, on a case-by-case analysis, and is not diminished by the employee's exercise of their right under CFRA, FMLA, or PDL. This is where you would be engaging in the interactive process and determine whether or not you can provide the additional leave or whether there is some other reasonable accommodation that the employee may be eligible for.